Good morning. And this judgment will help criminal side practitioner as well as public prosecutors to concentrate at the time of filing final report. What are the area left by which the other side can raise a gap in the chain of link of circumstantial evidence. So the murder cases are whatever may be the cases, direct evidence and circumstantial evidence are different in nature. The question of direct evidence being challenged on the ground of their presence or they are implanted as an eyewitness. So for circumstantial evidence are concerned, the prosecution duty is that there should not be any gap in the chain of link of the evidence. This case seems to be such a nature how prosecution failed or etc. The way how people manage to create doubt. All these two suspicion arises if this case is understood by reading the judgment. AR 2024 Supreme Court 5650. AR 2024 Supreme Court 5650. Karakattu Mohammed Bashir versus State of Kerala. See, actually what had happened, the appellant was having intimacy with one lady since her husband was at foreign. The problem was unfaithful one Gauri. Gauri seems to have stayed along with deceased sometimes and on the fateful day also the deceased seems to be with Gauri. So according to prosecution, the appellant as well as the Gauri had altercation in respect of this illicit intimacy of the second accused with the appellant. So an altercation, the appellant seems to have, that means accused A1, assaulted her and after causing her death, he took her body to nearby field 1 kilometer from the scene of occurrence. There he thrown the body and thereafter the prosecution, some witnesses found a body, so a body was inspected and 174 FIR initially filed. Thereafter by collecting evidences they have implicated A1 and A2. A2 for screening of offence, A1 for committing murder, and the trial court convicted the appellant and High Court also confirmed the judgment. The problem was Supreme Court acquitted the appellant on what ground? Number one, the important witnesses, the eyewitnesses who were available at the scene of occurrence, the children of A2, they have told that the deceased was inside the house and thereafter the incident had spoken. But unfortunately, according to those children witnesses, the deceased seems to have left the house prior to alleged time of occurrence. So that evidence seems to be not acceptable. Then question arises, one another witness saw him, appellant, going to the house of A2. But unfortunately that witness told that he did not saw his face, he saw backside of his body And since he had several occasions to noticing his entering into house of A2, he presumed and told that it was the he who entered into the house. So that was also not accepted by the then question arises recovery of weapon. Recovery of weapon was not attested by independent witnesses. So that is also they did not rely on. Then question of a bag containing clothes, and that bag which contained the deceased clothes or accused clothes was actually produced before the police on 23/8/1989, but actually it was seized on 27/8/1989, the Magjar. So that is also not reliable. Then question arises, the important aspect, the person, the body which was carried by the appellant to the field, in between one sawmill was there, which was used to be running and working around the clock. Therefore, the investigating officer did not strain to produce any witness as to was there any possibility of noticing the accused carrying the body of all these things. They say chain of circumstances had glaring holes and significant gaps. Conviction set aside, he was acquitted. Probably see the commission of offence was very 1989. The date of judgment was November 2020. That much of strain in the appellant facing. It's a very good judgment. Go through the entire very few pages, but ratios are most important. Understand. Rest is